provide some background information that outlines the legal principle relevant to the case. I will also discuss the main facts of the case, the issue, and the reasoning behind the judgment that was made of the case. The implications that arise from this case in regards to the tax practitioners will also be presented. The legal principle behind the case is Section 8-1 of the Income Tax Assessment Act, which is equivalent to Section 51(1) of the Income Tax Assessment Act 1936. This section provides that you may deduct from your assessable income any loss or outgoing to the extent that either it is incurred in gaining or producing your assessable income, or it is necessarily incurred in carrying on a business for the purposes of gaining or producing your assessable income. However, you cannot deduct a loss or outgoing to the extent that it is a loss or outgoing of a private or domestic nature. The following case between the plaintiff, the Federal Commissioner of Taxation, and the defendant, Cooper, was incurred in 1991 as part of the Federal Court reports. The taxpayer Cooper was a professional rugby league player in which he suffered from an unusual weight loss problem during the playing season. The weight loss had affected the taxpayer's ability to perform as expected of his position as a forward player, and thus affected the amount he was paid. Provided in the taxpayer's contract were different tiers of payments in accordance to the grade the taxpayer was selected to play. A win, when playing in the first grade, paid 5 times the amount in comparison to a win in the reserve grade. The club's coach had redressed the taxpayer's weight loss issue, in which the coach then instructed him to consume additional amounts of steak, potatoes, and bread, and to consume at least 1 dozen cans of beer per week in addition to his normal meals in order to retain an optimal playing weight. Following this, the taxpayer had made a claim of deductions for the amount of purchasing additional food and drinks for the income years of 1980, 1981, and 1982 on the grounds that the expenditure was incurred for the purposes of the taxpayer gaining an assessable income under Section 51(1) of the Income Tax Assessment Act 1936. However, the deduction that was claimed by the taxpayer was disallowed by the Commissioner. An appeal was then made by the taxpayer to the Taxation Board of Review, which allowed the appeal. However, following this, a further appeal was then made by the Commissioner to the Supreme Court of New South Wales. This appeal was dismissed by the Supreme Court, in which the Commissioner of Taxation then made a further appeal to the full Federal Court, which allowed the appeal of additional expenditure as not deductible. Robert John Cooper was then ordered to pay the costs of the Commissioner of the Taxation of the appeal. The Supreme Court orders were then to be put to a side, and the Commissioner's appeal to the Supreme Court was to be allowed. The main issue was whether the cost of additional food and drinks expenditure incurred by the taxpayer satisfies as an allowable deduction. The primary question is as to whether the expenditure incurred was necessary in producing the taxpayer's additional income. A relatable question also arises as to whether the expenditure was of a domestic or private nature, and thus an exclusion from the deductibility of the food expenditure. The reasoning behind the decision that was made by the court of the case was that the Commissioner of Taxation had identified 2 questions of law to be involved in the case, which was raised by any claim for an outgoing of a private nature under Section 51 of the Income Tax Act 1936 and the application of Section 51(1) to the facts of the particular case. The decision of the court to disallow the deduction of the additional food expenditure incurred was made in relation to the case of Looney and the Commissioner of Taxation 1958. This case justifies the lack of connection between the outgoing loss and the income-producing activity. This case was found in parallel reference as the essential character of the expenditure itself was not a business or working expense. The income-producing activity that is to be applied to the taxpayer is the training and the playing of football, in which allows the taxpayer to produce an income. The consumption of food is not part of the income-producing activity, though unless the food was eaten, the player would be unable to play. The food that was incurred by the taxpayer is additional food, which is therefore more than the normal requirement and does not form part of the income-producing activity. An important feature of the case was that the expenditure was described as in the appeal as additional food, which in a sense is of additional to the taxpayer's normal expenditure. However, there was no evidence provided that the taxpayer had actually suffered a medical condition, and the other players who played the same position was also instructed to make any other additional expenditure on food and drinks as well. The taxpayer's normal intake of food was found considerably less than the ordinary expenditure of the other players, and that the letter in which his coach had provided to the taxpayer was not a prescription that the taxpayer was obligated to follow. Rather than it was a suggestion to the taxpayer's diet intake. The essential character test of whether the outgoing excluded from the deductibility as private nature was submitted by the Commissioner, that the essential character of food will always be of a private nature with the exception of rare cases. The Commissioner had acknowledged the two cases of entertainment expense and the meal expenditure of the taxpayer whilst being away from home for business activity, which is stamped with the essential character as business expense. In application to this case, it lacked the factual background of business nature that applied to the other exceptions of the nature of food expenditure. Therefore, the decision was made by the court, and it was held that the additional expenditure that was incurred by the taxpayer was not compatible with the deductibility of outgoings provided in Section 51(1) of the Income Tax Assessment Act 1936. So what does this case mean for tax practitioners? The case between the Federal Commissioner of Taxation and Cooper presents many issues that may arise for tax practitioners in the deductibility of expenditure. It presents an issue in which the tax practitioner is to make a judgment as to how much of an extent is required for an expenditure to relate to their business or income-producing activity, and how much of the additional expenditure is required to what is classified as normal consumption before the expenditure is to be considered as business-related rather than domestic or private in nature.